Our first speaker today, first off the rank, is Derek Mortimer. So Derek, his firm is based in Melbourne. It's a boutique law firm practicing exclusively in the not-for-profit and charity law. His clients include private and public charitable foundations, trade associations and religious institutions. Derek has a reputation for assisting the resolution of internal grievances with not-for-profit organisations. He also advises on establishment of not-for-profit entities and applications for tax concessions and deductibility with the Australian Charities and Not-for-Profit Commission. So if you can all welcome Derek to the stage, thank you.
Well, welcome everybody, and I'm really looking forward to making my presentation on governance for all of you. Now, this presentation is really going to be focusing on case law. There are many good publications on governance, the ACNC, Philanthropy Australia, even a review of the model rules of Victorian associations will give you a bit of an understanding of the roles of committee members. But I don't want to send all of you off to sleep already, so I'm not just simply going to iterate an understanding of governance at board level. I want to present some cases to you to show how governance operates in a real context, and that might give you an understanding of the many different forces at work. I thought before I started on the cases, just to give you a quick run through of what governance means. The ACNC, the Australian Charities and Not-for-Profits Commission, has a reasonable definition of governance, and I've adapted it to basically apply to all not-for-profits. Basically, all sorts of processes and activities that your organisation conducts goes towards what is good governance. And the theme of my presentation will be that not all of governance rests entirely with the board or the committee of management. You will see that there's an interesting interaction between the members in general meetings and the board. Both of them have different roles, as the Associations Act actually quite clearly says that the management of an association rests with the committee, except for those powers that are left to the members in general meeting. So it's an interesting, if you like, separation of roles, and some of the cases that I'll present today will show that dynamic between members and the boards and committees of management. Now, I'm going to focus, and I've assumed that all of you, or most of you, will be, your organisations are either incorporated associations or companies limited by guarantee. My apologies to those of you who are trustees of charitable trusts, per se, who may be under trustee legislation, or whose faith-based organisations that are set up under their own statute. But I trust you'll bear with me for those of you who aren't caught by the Corporations Act and the Associations Act. A basic tenet of corporations and associations is the idea of the statutory contract. And I'll just run this past you before I get talking about the cases. The idea of the statutory contract is that the constitution or rules of your not-for-profit bind members to each other and bind the board members to each other and to the members. And that's statutorily binding, and indeed board members can, if necessary, take action to enforce those rules against each other if the contract is broken. Usually it's the constitutional rules that constitute the contract. Sometimes there's discussion amongst lawyers whether bylaws and policies may also form part of the contract, and it really does depend on the context of the arrangement. Before I continue, I should say that I've tried to give a concise discussion of principles of law around board governance, but please do not take my comments here as being advice, legal advice. Please don't rely on the advice. As you will see, so many things can depend on the situation. It just requires one additional fact and the entire circumstances might change. So please take my comments as statements of principles that may or may not apply in your particular case. So for today, I've selected a number of issues, if you like, that I've found typically arise with governance issues. So I'll be talking about admission of members, maintaining a register of members, improper use of position, mergers, meetings and quorums, etc. And these are the main things. We did a survey before we began this preparation for the seminar, and these seem to be the real issues that our clients, at least, wanted to ventilate in a public meeting. So I hope these topics will be of interest. So the first topic I'm going to talk about is just the simple act of admitting members. Now, I'm sure all of you would know that it's the board or committee of management that usually has the responsibility for admitting members. It might sound like a very straightforward and uniform and uncontroversial process, but there can be many disputes that arise because it's not clear who the members are. So Rana and Servery was a case where there was basically an executive council, a committee of management of a faith-based organisation in Sydney. And Servery was the president and Rana was a member of the executive. Now, the issue was whether 175 people had actually been validly admitted to the association. Rana said that they had been admitted. Servery and the association tried to say that no, they hadn't been admitted. And the court found that, in fact, the 175 people hadn't been properly admitted. And I'll just run through what had happened in this case. And there was, what prompted this was that Rana wasn't happy with the way the executive was, the direction that the executive was taken. So, as you could imagine, at least some of those 175 people allegedly admitted were, if you like, on Rana's side. Now, the issue before the trial judge, it went to appeal, but the issue before the trial judge on this slide was whether the admission process followed the requirements in the rules. And there was a good deal of legal argument because the Constitution was very scant on the details of how people could be admitted. And the judge had to then say, well, we're going to apply the model rule regarding admission of members, and most of you would be familiar with the model rules of associations in Victoria. It specifies a process by which people are nominated, they're seconded, an application form is submitted to the committee makes a decision, etc. Now that sounds very straightforward, but in this case the rules of the association were silent on that process, so the judge said, well, we're going to apply the model rule to see if this works. And the judge said, well, you haven't given us evidence to Rana. He said, you haven't given us evidence to show that nomination forms were filled in, people were seconded, nominations forms were given to the committee. There was some evidence that some sort of resolution was actually made by the committee, but the process to get to that resolution was by no means clear. So the judge found against Rana and said that those 175 people weren't admitted to the association because the process for admitting hadn't been followed. Now this went to appeal, and I'll talk about that in my next slide, but it's really the process of admitting is something that ought to be followed very closely in case there is a dispute about who is or who is not a member. In Mortimer and Dragicevic, another case concerning memberships, there are a number of persons aligned to Mortimer, and they attempted to have their membership applications put forward to the committee. The committee rejected those applications, and Mortimer went to court to dispute that decision. And there's an important principle here that the judge enunciated. Basically, he said, it's really up to the committee. The rules say that it's entirely up to the committee who is and who isn't admitted as a member. And I would imagine many of you would be familiar with that basic principle. But he did say that it's important that directors, committee members act for a proper purpose, and when they're deciding to admit or not admit members, that that's done with an interest of the association in mind, the objects, the purpose of the association, that it's done in good faith, and basically trying to create some criteria that does away with, if you like, personal dislike or approval of particular people. The judge also said it's entirely appropriate for associations to reject members if the association simply doesn't have the capacity to take in new members. So there's plenty of scope there for boards and committees to reject membership, but it does need to be done in good faith. Maramalov also sought orders to an injunction to prevent an annual general meeting going ahead. And the court refused to grant that injunction. It was simply over-the-top request, even though there was, in fact, a dispute about who could be members and who couldn't. The judge actually accepted that whilst new memberships were validly refused, he also said that some applications to renew membership couldn't be validly refused by the committee. That is, these people, these renewal of membership people, were still members, and if they were to be removed from the association, that should be done through a normal disciplinary or grievance process. So it wasn't up to the committee simply to, if you like, get rid of some troublesome members simply by refusing to process their renewal applications. Now I'll move on to Rana and Servery again. Rana was persistent. He wasn't happy with the trial judge's decision to say that basically the process to admit members hadn't been followed. So he went to the Court of Appeal and he basically said, look, there might have been some deficiencies in the process, but despite that, there's still a decision of the committee to admit members, and you should accept that decision, even though there might have been some deficiencies in the process. Now, the Court of Appeal judge took a different tack. Instead of looking at the process, because there was some dispute about whether the process under the model rules or under the association's own rules applied, he took a different tack. And he said, bring into evidence the minutes of that committee meeting. And the judge said that if the minutes have been signed by the president, they are conclusive evidence of what occurred at that meeting, and he accepted the minutes into the evidence. As it turned out, the minutes were handwritten, at times illegible, and there was a good deal of toing and froing, some discussion on admission of members. At one point, it was a faith-based organisation, and the meeting broke for prayers, and they came back. It was very late at night, and there was some sort of decision to say, yes, we'll admit members, recorded in the minutes. And the secretary, in his affidavit to the court, said after that resolution, he then went about the process of making up a list of members. So actually, the members weren't known at the point that the committee approved the membership. And there was also a great deal of cross-examination of the secretary. The list of members that he had compiled had been partly crossed out and replaced with others, and the court came to the conclusion that whilst there was a general intention to admit new members, as evidenced by the minutes, they couldn't prove who actually were the new members. So he said it didn't matter, even though he came to the same conclusion as the trial judge, it didn't matter if the process had or had not been followed, you simply couldn't tell who the new members were. So Mr. Rana was once again unsuccessful. So this is a lesson about keeping accurate minutes of meetings and being very clear when you're admitting new members to record the names of those people. Sounds very straightforward, but this went to Court of Appeal. A particular association had a large membership, ran schools and had other substantial assets. So you can imagine there would have been a great deal of passion between the parties. Now, acting for a proper purpose, and I'm going to bring in a story of a golf club here. In this case, there's a company limited by guarantee. It was called at the time Kingswood Country Golf Club. It had, that's right, Kingswood Country. And it had some land at Dingley, the 18-hole golf course, valued at around $70 million. And there was discussion amongst the board about merging with another golf club, the Peninsula Golf Club. It seems from the evidence in the case that the board was rather committed to it. The judge said that it wasn't an even-handed approach to whether to merge or not merge. Kingswood had entered into a heads of agreement with Peninsula about the merger. And the judge said, well, yes, there was some evidence that the board was already moving down that pathway to merger without actually discussing with the members. Also, in August of the year 2013, an information booklet was sent out to members of Kingswood saying these are the benefits of merging, and particular benefits said by selling the 18-hole golf course at Kingswood, that money could be partly used to pay off some debts at Peninsula. So if you're listening carefully, this is Kingswood's, the benefits to Kingswood are paying off a debt of another golf club. A meeting was called in September of that year, and two resolutions were passed. One, a resolution of members saying, yes, we should merge with Peninsula, and another resolution directing the board to admit all of the 1,000-odd members from Peninsula to Kingswood so that Kingswood could become the merged entity. As you can imagine, the numbers show it. 63% of members voted in favour of the merger, and the balance voted against. So there's quite a dissension amongst members about whether the merger should go ahead. And I've got a question to ask you now. If you're doing your numbers, what do those numbers tell you about the quality of the resolution that were passed? So 64% against, for, and 26 against. It was an ordinary resolution, wasn't it? And I would hope you would all know that a special resolution requires 75% of members to approve changes to the Constitution, major changes such as mergers. So there was a problem there. Now, a number of people, the action went to Supreme Court. There was a particular member of Kingswood who wasn't happy with what had happened, but certainly there was a great deal of support. But he took about a year to get around to actually lodging some documents at court. He was prompted because part of the information sheet that was sent to members said, we're not going to sell the Dingley land, the golf course, for 3 years so that to allow a transition. And in fact, the board then made attempts to sell the land about 1 year after the merger. So he went to court, and the court actually said, in this case, the board had been acting for an improper purpose. There was oppression of the members, that they hadn't been really given an opportunity to consider the options, whether to stay or merge, that people hadn't been given an opportunity to discuss the benefits or not the benefits. And he also found that the resolutions were in fact invalid. And the judge said he had no problem with Kingswood actually being the merger vehicle, but if you're going to be admitting 1,000 new members, it has to be done through the Constitution. And in this case, the Constitution said that new members had to be proposed by existing members of Kingswood, and that didn't happen. There was an en bloc admission of some 1,000-odd Peninsula members. The Constitution also said that members had to approve any disposition of land, and members hadn't done that. So the judge, if you like, found a case of oppression of members in this case. It's really a discussion about how mergers, if they are going to happen, how the process of informing members and ensuring members understand the consequences and that various resolutions are in accord with the Constitution. So the judge found for the people who didn't want the merger to go ahead. But the problem was, what do we do about it? Because the merger had happened 1 year down the track. Some $200,000 in due diligence had been spent on the proposed sale of the 18-hole golf course. And the judge said, well, whilst we find oppression in favour of the plaintiff, we can't prevent this going ahead. The plaintiff has taken too long to actually bring his complaint. If he had acted quickly, immediately after the meeting with the resolutions, he would have had a better chance. So there's some lessons there about, on both sides, if there is a problem, if members see a problem, it's important to act, not stew over it for a year. If you have a problem with the way a meeting has been conducted, one way or another, try to action that, because you may not be successful in letting it stew for a year or more and then trying to bring it up into court. But there's also a lesson there about how boards conduct processes that might lead to mergers, and the court wasn't very impressed with the way the board had acted in this case. He felt that there was a predisposition towards merging and that it hadn't been conducted in an even-handed way. My second case about improper acting not for a proper purpose is also an admission of members case in Petty and the South Australian harness racing. There was an AGM coming up. There was a great deal of discussion about removing some of the executive, and at the same time there was an influx of new membership applications. How many of you have experienced that when there's some controversy coming up to an AGM and all of a sudden you get a whole lot of new members? Ambush, stacking, those sorts of things come up. So it went to court, and the court said in this case it was improper for the executive to refuse membership to the new members. He felt that it was being done simply for the purposes of keeping people who were antagonistic to the current executive outside of the membership. He said that it's really up to the members to elect board members. So if new members come into the association and they want to sit on the board, well, it's up to the members to decide. It's not up to the board to preempt a decision of members in general meeting to decide who should and who shouldn't be on the board by excluding those people from membership in the first place. He also said that in some cases, some of the membership applications may well have been in good faith, that they weren't people who were simply on a mission to derail the current board. And by refusing all of the membership applications, people were denied an opportunity to actually participate in the affairs of the association. So the judge found against the Harness Racing Club executive for refusing the membership applications. It was done not for a proper purpose. Now, this is a case where I can only feel for the directors of the Berry Club. It, I think, was a golfing club as well. It was a company limited by guarantee. And as you would know, there is a duty that can't be delegated to anyone. That's the duty of directors to declare whether the organisation is solvent or not. And as it turned out, the company had been running at a loss since 2010 through to 2013. In later evidence, an auditor said it was hopelessly insolvent a good 6 months before the events actually occurred. On the 11th, I think, of January, a liquidator met with the board and said, "You are insolvent." And on the 12th, the board realised it needed to act and make a declaration of insolvency and appoint a liquidator. All fairly straightforward, but there was a problem. The board was meant to be a maximum of 9 members with a minimum of 5. There were in fact only 4 members of the board. One of them had cancer and was in hospital, and another member had advanced Alzheimer's and was really beyond capacity to make a decision. So you have 2 members of the board, nowhere near the quorum, and they have faced with this momentous decision of declaring insolvency and appointing a liquidator for a services club, which many members enjoyed the facilities. It's easy for me to say. I don't know exactly whether the board had tried to bring these issues to the attention of members in the past. Members, for example, do have a right to demand or request the board to have a review or an audit undertaken of the books each year, and you would have liked to have thought that these issues would have come up well before the particular January of the year, especially when an auditor is saying that it was hopelessly insolvent a good 6 months before, well before the previous AGM. But that didn't happen. It also, as I say, I don't know, but perhaps it would have been good if the directors had co-opted 1 or 2 more directors on to build a quorum, and directors do have a power to appoint casual vacancies. But I can imagine that in such a case, if I was looking for somebody to sit on a board that was going to declare insolvency, people would be finding other things to do. So the directors were in an awful position. They approved a decision to declare insolvency at the bedside of the person the board member who had cancer, and liquidators, Clifton and Hall, were appointed. As these things go, some members didn't like that. They sought their own legal advice, and Clifton and Hall, the liquidators, became anxious about their position, whether they were duly appointed under the Corporations Act. So they went to court to get a ruling from the court. And the court said, yes, there was a major procedural error in not having a quorum for the board to make a declaration of insolvency, but he couldn't see anything, really any mischief arising, and he actually approved the appointment of Clifton and Hall so that they could go about their job of liquidation. Of course, you don't want to get to that point, but that's one of those things, as I say, I can only feel for the board in such an invidious position. One member with Alzheimer's, another with cancer, no one apparently being willing to step up and help the board through a momentous decision. This next case, Anandamarga Prakaraka Samha, this is the number 7 case. Obviously, there's been a few cases beforehand. The entity is a faith-based organisation. Apparently has assets of many millions of dollars, $1 million a year in turnover, and there's been all sorts of disputes about the operation. In number 2 case, Her Honour Justice Dodds-Streeton made a ruling that it's really, there was a dispute about who were members again and who were directors, and she said the first port of call is to work out who the members are, because by that, once you've done that, you can work out who your directors are, because it's the members who appoint the directors. Now, in the number 7 case, precipitated by the number 6 case, in the number 6 case there were some discussion about whether the board was functioning, whether the organisation was functioning, and Her Honour found in number 6 that financial reports hadn't been properly prepared and annual general meetings hadn't been held for the previous 10 years, and all sorts of other major anomalies. But at the time, she wasn't convinced whether she could make an order to wind up the company on the just and equitable ground under the Corporations Act. So she ordered an expert to be brought in, and the number 7 case dealt with that. The expert were Ferrier Hodgson, and they conducted a review of the operations of Anandamarga and said that at the current time, everything was in order. So Her Honour said in this case, had that not been the case, had the state of affairs been the same as it had been for the previous 10 years, no annual general meetings, financial reports not quite clear, she may well have ruled that winding up was the only thing to do. but because at the time, somehow, maybe the presence of litigation actually was the kick in the pants needed for the board to get its house in order, and it wasn't wound up. Any questions so far? Ray?
What would have been the impact then on the, if you got new board members on the board and now suddenly they're insolvent, so what is the impact on the board members of this happening, probably in the old ones and the new ones?
As in personal liabilities? There's a business judgment rule for directors. It's a safe harbour. And basically it says that if you make a decision that's based on rational evidence, and if you bring in experts such as accountants and auditors, you can rely on that opinion, and if providing you've made a reasonable decision based on reasons, you will be protected. So in the case of Berry, if new directors had been, and it's not for me to be telling Berry how to operate, but in the case of an organisation like Berry, if new directors had been brought on basically to make a decision that the company was insolvent, I would imagine that they would be relying on an auditor's advice to make that decision. So that's their safe harbour. I don't know how they allowed the organisation to run for so long whilst insolvent, but I also agree that or you may not agree, Rake, but insolvency can be a bit of a rubbery concept at times, so maybe they didn't see it. But in such a case, I'd say bring in an expert, an accountant, auditor, give an opinion, and if the directors base their decision on that opinion and they have a reasonable belief that the person giving the opinion is an expert in this area, well, then they will be protected from personal liability.
Yeah, but what now for the members, the existing four members, let's say it's been going on for a few years, are they personally liable?
There's probably a case to say, have they been diligent in looking at the books? There is a well-known case, the Centro Properties case, which was a for-profit case where the directors were found not to have acted diligently in really making a cursory, I hope I'm not doing a disservice, but a cursory review of the financials, when the judge said they really should have better informed themselves and simply not relied on statements of others, and made a rational decision themselves that the material being presented was a true and fair presentation of accounts. So it's no point saying, look, we've got the CFO doing this and our accountants, so therefore as directors we don't have to worry about it, we'll just tick the box and say the financials are approved. So as I say, I can't guess what happened at Berry, but why not bring these things up to the members and say, look, we've got a cash flow issue, we've been running at a loss for the last few years. The members themselves can actually request the directors to conduct a review or an audit of the books. So there are safeguards in place if they're taken up. But look, it might have been that the members in that case were saying, well, look, we're enjoying golf, that's your problem, you sort it out. And it came to the mess that it was. Yes?
You mentioned that these cases are mostly relevant to incorporated associations and companies limited by guarantee. Would they also be relevant to cooperatives?
Yes. Not-for-profit trading cooperatives, cooperatives that prevent the distribution of assets back to its members other than the nominal value of their share, if it's a shareholding cooperative. The principles are largely the same. Pardon me, and in fact, the Cooperatives National Law, which is codifying cooperatives legislation, has similar legislation regarding the duties of directors, rights of members to convene meetings, etc. The rules are different for trustees of charitable trusts, and they can be different for statutorily created organisations. Some faith-based organisations are created by their own statute, so it's necessary to look at the statute in those cases. All right, thanks. So Ananda Marker, basically the court said because the organisation has its act together and Ferrier Hodgson has said so, she wasn't prepared to grant an order winding up the company on the just and equitable ground in the Corporations Act and allowed it to continue. I'm not sure whether there's an Ananda Marga numbers 8 case, but these things do have a tendency to play on. Now this board members' access to records is one of the classic questions I get from board members. Can we access the records? Of course you can in most cases. But this particular case, Pine Rivers Caboolture, it shows enormous amount of conflicting forces at work which confused the issues. I'm just trying to remember which one of the two was the peak body. I think it was group training, the respondent. There was a peak body, group training organisation, and its membership comprised, I think, 7 incorporated associations, including the plaintiff, who were the members. So it wasn't individuals who were members, it was incorporated associations. All of them were involved in group training, and the peak body basically received government funding. Its executive then made a decision to award group training funds to each of its members. I think 4 of the 7 members were aligned in a block called Skillforce, according to the case, and the other members, group training members, were unaligned. And the unaligned members basically said, hang on, all of these contracts are being awarded to the Skillforce group of members, and they wanted to see what was going on. So in the first case, the trial judge, the case proceeded on the idea that members should be entitled to access the board's documents. And the trial judge said, well, no, that doesn't apply. Members don't have a right, as of right, to access board documents unless the board actually decides to do that. You might be familiar with those basic requirements. So the trial judge knocked out the plaintiff's claim. Plaintiff then went on to appeal, and this time their case wasn't based on, the right of members to access, but the members in fact had appointed representatives who sat on the board of the peak body. So in that case, in the appeal case, they said, we don't want to see the documents as members, we want our representatives as members of the board to be able to access the documents. And the court in the appeal case said, whilst there isn't an express right of board members to access all board documentation, it's an implied right because directors need to be able to discharge their duties, and if they're going to do that, they really need to be informed. So the Court of Appeal said, yes, the representatives of those unaligned members are entitled to see all of the documents. There's a good deal of argument, as you can imagine, claims of commercial in confidence, conflicts of interest. I might even say that if you like, the Skillforce block, the representatives of the Skillforce block on the board of the peak body perhaps themselves had a conflict if they were awarding contracts only to their own members. These are some of the many different forces pushing and that sometimes confuse the issue, which seems very straightforward, that of course directors and committee members should be entitled to access whatever jolly documents they need to be able to discharge their duties. Keeping a safe workplace is another issue that comes up from time to time. Board members ask me, what's our responsibilities? I like this case because, self-deprecating humour, the board of the cooperative were lawyers or student lawyers, and they made some colossal stuff-ups, basically. It came down to what I call role confusion. There were 2, according to the case, there was a manager of the bookshop and an assistant manager. But unbeknownst to the manager, the assistant manager had a direct report relationship with the board. So there was a confusion that whether the manager was entitled to direct the assistant manager. It was found in the case that the manager had behaved in a bullying and intimidating manner, so there's no question that the behaviour wasn't acceptable. But it was almost an accident waiting to happen, because the assistant was talking directly with the board and taking directions from the board, and wasn't taking directions from the manager. It's recorded in the case that the manager ended up allegedly throwing a book at the assistant manager, and the assistant manager took out a workplace claim, and she was successful. And she was successful against the board, the managers of the cooperative, because they had failed to keep a safe workplace. They'd failed to respond to complaints. I think the assistant manager had said, look, there's an issue, but just note it, she'd said to the board, but hadn't actually explored a grievance process. But really, once notified that there's a problem that could affect workplace safety, the onus then rests on the board to act. So I think it was a $300,000 payout, if I've got my figures correct, and it certainly made the newspapers, and it's a case recorded. So the lesson there is keeping a safe workplace. Be clear on your position descriptions, who's reporting to who. So much dispute can be dispelled if you know who you are entitled to direct and who you must take directions from. This final case is about disciplining members. Frequently I'm asked, look, we've got a person who's become a bit troublesome, whether they're on the board or in the general membership, how do we go about it? Associations and companies, associations have a requirement in the statute that procedural fairness is given, and case law also supports the idea that procedural fairness for disputes is given to members in a company limited by guarantee. Now, procedural fairness, basically, it's a fluid concept, but basically it says that members are entitled to know the charge against them. They have to be given an opportunity to be able to respond to those charges, and the decision maker must be unbiased. But how that plays out in particular contexts really, it does depend on the severity, the nature of the claim. Obviously, a claim of sexual abuse is going to have a greater standard of proof around what's procedurally fair, rather than, if you like, a complaint that so-and-so hasn't actually emptied the waste paper baskets in the boardroom. But the basic principle applies. Now, in this case, Subeski, there was a bit of background. Subeski had arranged for some work to be done, and the fees were then going to be given to his organisation, Macedonian Orthodox. And there was an accident, and the painter, or the tradie, injured himself, and there was a dispute about whether Subeski was liable as the overseer, or whether the church body was liable. So that was kind of the background. And Subeski had got very aggressive. It's recorded in the case, and it came to a head. And the executive decided we've got to have a disciplinary meeting. And because he had been physically or verbally aggressive in the past, they thought we have to put some extra conditions around his attendance if he really wants to come. So they sent him an email. They didn't disclose where the disciplinary hearing was going to take place, and said, please notify us within 3 days prior to the time of the hearing if you are going to come, and to provide your, if you like, rebuttal to the claims against him. Now, Subeski didn't reply by the due date. He in fact replied on the day that the hearing was to take place, and he also found out where the hearing was going to take place. And he turned up. The gates were locked. After a great deal of agitation, he was allowed in. police were called and he was asked to leave. And so he went to court and said, look, this wasn't fair. I wasn't given a fair opportunity to present my case to the disciplinary hearing. And he argued about needing to be given notice where the meeting is, needing to have an opportunity to respond. Now, in this case, the court said, given the history of Mr. Sebeski, his aggressive behaviour, it was quite appropriate and not at all out of the bounds of what is procedurally fair to request him to give notice if he was going to attend before 3 days prior to the meeting. Because he hadn't done that, he basically had denied himself the opportunity to respond to allegations. And the court said what had occurred here, even though it was unusual, this extra condition being placed on the person to be disciplined was still quite, in the context, was still procedurally fair. So it's a matter of judgment about what is fair and what isn't. And of course, sometimes these disciplinary type meetings can go, they can become very heated, and those hearing the matter are entitled to some way of protecting themselves if there is an issue. So procedural fairness doesn't demand that the parties have to meet each other and have fisticuffs. The mere idea that they should be able to exchange points of view doesn't oblige physical confrontation if necessary. Now that's the basis of my presentation on governance to you, and I've tried to cover some of the issues that I see from day to day where board members have issues about admission of members, acting for proper purpose, what is a fair decision under the circumstances. Mergers is certainly a hot topic. Many times I've had board members come to me and say, look, we've got a cash flow issue, there's a great opportunity to merge. I've even attended meetings with the potential merger partner, but then they've said, well, we're not sure whether the members are going to like it or not. And in those cases, their decision, not mine, but a fantastic decision, they've said, we're not going to put a resolution up to members, we're just going to have a discussion meeting with the members and explain what's going on and see what they say. And in one particular case, the members said, oh yes, there is a cash flow issue, but merging isn't the solution, let's find another solution, we want to stay independent. So that, I think, was a really sensible way of approaching some of these issues. In other circumstances, we're nearly time, Paul, is that? I'll disappear. Other circumstances, the buck rests entirely with the board, especially with insolvency, but there is help there in having independent expert opinion if needed. Thank you very much.